Good morning, everyone. I would like to welcome you on this nice rainy gray day to Assembly Judiciary. With that, welcome to everyone that is watching on Nellis and on YouTube over our legislative YouTube channel. Secretary, please take the roll.
Assemblywoman Bilbray Axelrod. Assemblywoman Cohen. Assemblywoman Considine.
Present.
Assemblywoman Gallant. Assemblyman Gray. Assemblywoman Hanson. Assemblywoman Hardy. Assemblywoman LaRue Hatch. Assemblywoman Marzola.
Here.
Assemblywoman Mosca. Assemblywoman Newby. Assemblyman Orentlicker. Assemblywoman Summers Armstrong.
Present.
Assemblyman Urich. Chair Miller.
Here. And please mark any members present when they arrive. With that, just a few housekeeping issues. Again, asking everyone to turn down any type of electrical alarms or anything that can make noise. We also will have a public speaking comment at the end of today's meeting. Today on the agenda, we have 2 bill hearings and 2 work sessions. So we will start first with our work sessions. So with that, again, we went through our work session yesterday, so everyone realizes we're just voting bills out of the committee to be presented onto the floor. With that, I'm going to ask Ms. Diane Thornton, our policy analyst, to explain the first bill to us.
Thank you, Chair. Diane Thornton for the record, Legislative Council Bureau. Our first bill on work session is Assembly Bill 17. This bill revises provisions relating to penalties for driving under the influence of alcohol or a controlled substance, heard in this committee on March 6th. This bill removes the requirement that a person who is convicted of driving under the influence of alcohol or a controlled substance must dress in certain distinctive garb while performing community service ordered by a court. And there are no amendments to this measure, Chair.
Thank you, Ms. Thornton. Members, are there any questions? Not seeing any questions, I'll entertain a motion.
Motion.
I have a motion from Vice Chair Marzola. Do I see a second from Assemblywoman Summers Armstrong? And with that, all those in favor, please say aye. Aye. Anyone opposed? The motion passes unanimously, and I will give the floor speech to Assemblywoman Summers Armstrong. Our next bill, Ms. Thornton.
Thank you, Chair. Assembly Bill 231 revises provisions of the Uniform Commercial Code, heard in committee on March 8th and sponsored by Assemblywoman Backus. This bill enacts the 2022 amendments to the Uniform Commercial Code, which is a set of uniform laws governing commercial transactions. The 2018 amendments to Article 9 Code are also adopted. Among other things, this bill revises provisions related to emerging technologies, and there are no amendments to this measure.
Thank you, Ms. Thornton. Members, are there any questions? Assemblyman Urich?
Apologize, Chair. I don't know if this is the appropriate time for a question, or I didn't get a comment, I guess, after we do the motions. Would that be the better time? Okay.
Yes, the comment will be after.
Thank you, Chair.
Okay, with that, not seeing any additional questions, I will entertain a motion for due pass. Motion. Okay, I have a motion by Vice Chair Marzola and a second from Assemblyman Gray. With that, are there any comments? Assemblyman Urich.
Thank you, Chair. I just wanted to note that since our hearing on this matter, it has been brought to my attention that there have been other similar provisions that have been recommended to other legislatures and jurisdictions, and I was able to spend a little bit of time looking at it. It does not look like Nevada has included the concerning language that were recommended by the UCC committee, and therefore I will be voting it out of committee, but I do reserve my right to change my vote on the floor.
Okay, thank you so much, Assemblyman. And again, we just ask that you let us know, but respectfully, thank you. With that, I will go ahead and take a vote. All those in favor, please say aye. Aye. Anyone opposed? Again, the motion passes unanimously, and I will assign that floor speech to Assemblywoman Backus. Next on our agenda, we have 2 bill hearings. So the first bill hearing will be Assembly Bill 229, and this is presented by Assemblywoman Bilbray Axelrod and Jim Hoffman. This bill revises provisions relating to sentencing. I will say that there was a late amendment also that's on Nellis now, members, so if you want to pull that up as well. And we'll give the Assemblywoman a few moments to get settled. And so, Assemblywoman, when you are ready, please proceed.
Sorry, knocking stuff down. Okay. Good morning, Judiciary Committee. I'm Assemblywoman Shannon Bilbray Axelrod, and I'm here to present Assembly Bill 229 for your consideration. First and foremost, I want to tell you that I both know and believe wholeheartedly that the opportunity for parole is an act of grace by the state, and the impact of the victim should absolutely be considered in every hearing. The intent of this bill, as amended, which was my original intent of the language, specifically deals with the final discretion of the board in considering whether to grant parole. This bill, as amended, gives guidance to the parole board to establish a presumption in favor of granting parole under certain circumstances. This gives some certainty not only to the inmate and their loved ones, but also to the victims and their families. In an effort to ensure public safety, the mission of the parole board is to render fair and just decisions on parole matters based on the law, impact of the victim, and the community, with the goal of successfully reintegrating offenders back into society. Section 1 of the bill as amended establishes a presumption in favor of granting parole if a convicted person has not, 1, committed a major violation of the regulations of the Department of Corrections that is punishable as a felony in the immediate 12 months preceding, or to simplify it, really hasn't been written up for a major event, and has not been housed in a disciplinary segregation for conduct that is punishable as a felony in the immediate preceding 12 months, or has not been released on parole previously for the current sentence. Section 1 also requires the board not to consider whether a person has appealed their sentence and eliminates the requirement that the board must provide greater punishment for certain convicted persons. In other words, when a person is sentenced at that point in time, they go to prison. They know what their minimum time is before they can be released. That person who is sentenced, their family, and the victims all know that day when the person enters prison that if the offender lives on the inside the way that they should be living on the outside from that day forward, when the parole day comes, they can and should be paroled. When the offender enters prison, all of the facts in the case are known. The worst facts are already digested and taken into consideration. With the sentence and the negotiations, those facts all remain static. The fact should not once again be relitigated by the parole board. Once someone is sentenced, the next phase should begin, and in Nevada, that's punishment and rehabilitation, which is done by the Nevada Department of Corrections and their programs. The facts of this case in which the facts of the case in which they were convicted, all the facts that happened before the time that they entered prison cannot be changed. Those things have already been considered at trial and sentencing and should not be reconsidered at the parole hearing. The role of the parole board is not to look at the offender as if they were an inmate. The role of the parole board is to look at the offender as they were an inmate and not to retry the case. When a judge and/or jury sentence the offender to a term of years, and then the offender enters the system, does everything right, serves their time, never gets a write-up, is educated, works, is a model inmate, and then is denied parole just because their initial offense was just too offensive. It's a miscarriage of justice, and quite frankly is costly to the state of Nevada. Anecdotally, I've heard the parole board ask questions like, if your loved one was killed, what's enough time? Or do you think you should spend less time in prison with your co-defendant who received the same sentence? The function of the parole board is not to relitigate the facts or sentences opposed by the courts. I will now turn the presentation over to Jim Hoffman from the Nevada Attorneys for Criminal Justice for additional context, and then we will both stand for questions.
Thank you, Assemblywoman. Good morning, Jim Hoffman, Nevada Attorneys for Criminal Justice. So when I was researching this bill, I was kind of surprised. I thought that every state had parole. It turns out there are 17 states that just got rid of parole entirely. There are another 7 states that have this presumptive parole, which is the centerpiece of this bill. Those states include, those states are Michigan, Pennsylvania, Colorado, Vermont, Hawaii, New Jersey, and Mississippi. And I want to focus on the Mississippi one a little bit. The Mississippi version is actually more friendly towards inmates than the version we have in the bill. So in the bill, parole is presumptive unless there is bad behavior in the last 12 months. And that bad behavior, that's anything that's a felony. Minor felonies up to serious felonies. That's also if you've been out on parole and you got violated. Mississippi doesn't have that. Mississippi is just, if there's bad behavior in the last 6 months, you don't get parole. The Mississippi version also, there would not be a hearing in most cases. In Mississippi, there's only a hearing if law enforcement specifically requests one. The Nevada version, it's a 12-month period for bad behavior, and there's always a hearing. So there's always a chance for the parole board to review what people are doing. Our thinking with this bill was that when you're sentencing someone in court, there are a lot of rules that the judge has to follow. The judge has to follow rules about not giving a cruel and unusual punishment. The judge has to follow the statutes that the legislature has laid out. The judge has to base their sentencing on facts which are not highly impalpable or suspect. There's all these rules that judges are governed by. And if the judge screws something up, it gets appealed to the Nevada Supreme Court, and the Nevada Supreme Court can check it, make sure everything's going right. As the Assemblywoman said, parole is an act of grace. In a theological context, grace is something that everybody gets, whether they deserve it or not. But that's not what it means under Nevada law. What act of grace means under Nevada law is there is no appeal, there is no kind of check or oversight. The parole board is the final decision, and if you don't like the decision they made, you have no recourse. And this is nothing against the parole board. They do a good job in many cases, most cases. But there are 7 people on the parole board. They hear hundreds of cases every month. So in that circumstance, it's really easy for them to default to just looking at the offense conduct. Just saying, oh, you're in here for this crime? Well, that's a bad crime, so parole denied. We believe that there needs to be a balance of both individualized discretion and rules and guidelines. We believe this bill is a good balance, and that's why we're here presenting it. Thank you.
We're ready for questions.
Thank you for that presentation. And just give me a moment to see if there are any member questions. I actually will start with just a clarifying question on the amendment. So the amendment we see on Nellis, there's a lot of language in blue in section 3, but I just want to make sure that I'm correct in looking. The actual only new language you're adding in the amendment is number 4. Because the rest of section 3 looks like what's currently in the bill as new language?
That is correct.
Okay. So that's number 4, and then creating a new number 5. Thank you. With that, we do have a question from Assemblywoman Mosca.
Thank you, Chair, and thank you for this presentation. Do we know around how many people are being denied parole in our state right now?
I do not have that number. I know the parole board is here. I believe they would be better placed to testify to that.
Thank you. Could I have a member of the parole? Yes, please. Please approach and maybe stay for a few minutes in case there's other additional questions.
Chris Rico for the record, and I very proudly wear the Nevada Wolfpack banner.
They're in the tournament. They have to.
Chair, may I answer direct? So I can pull up some of that for you here, if you will bear with me. So the grant rate, and I'll start since I've been here with the parole board, and I've been the chairman since 2018, our grant rate, the 5-year, what I have broken down that we've used for other presentations is the 5-year grant rate from fiscal year 2013 to 2017. We averaged a 55.19% grant rate. So in essence, 45% of those were denied. Since being in this capacity and chairman and working to, do everything we can to take a good look at that, our average grant rate over the past 5 years is 65.87%. That's an increase of 11% over the course of the last 5 years. We understand that we're here to grant opportunities to individuals, and sometimes those individuals may not get granted. And so the numbers, the denial rate is approximately 34%.
Okay, thank you for that. Our next question is from Assemblywoman Cohen.
Thank you, Chair. So I have a question about the amendment with the language that constitutes a felony. So, for instance, Section 1, Sub 3, Sub 1, 3B1 commits a major violation of the regulations of the Department of Corrections that constitutes a felony. So if someone commits a misdemeanor, would parole still be granted, and then there could be new charges for a misdemeanor? I mean, what happens with something that isn't a felony?
Thank you for the question. Jim Hoffman. So that language is in there because the list of major violations of the Department of Corrections is really big. That includes felonies, it includes misdemeanors, but it also includes more minor things. So if you have a job in the prison canteen and you don't show up, that is a major violation. My favorite one, if you have a copy of the regulations, that is a major violation for some reason. So the point of that language was we want to make sure if people are doing really bad stuff like felonies, the presumption goes away. If they're doing less bad stuff like a misdemeanor, the presumption is still there, but a presumption is not like a hard and fast rule. The presumption is just the starting place. So if somebody commits a misdemeanor, the parole board can look at the facts of what that misdemeanor was, and they can decide, oh, this is too serious, we're not going to give this person parole. The point of the presumption is just to start from the perspective that people should get parole, and then the parole board is still free to consider any reason that they should not.
Thank you.
Our next question is from Assemblyman Urick.
Thank you, Chair. I just getting the amendment or seeing it this morning, and so I want to confirm, because in reading the original bill, I had some concerns about the removal of what was then subsection 4 to NRS 213-10885. And it looks like through this amendment, I just want to confirm that has been, the removal of that section is now not going to occur under this amendment. Okay, great, thank you.
Shannon Bilbert, Axelrod, for the record, that is correct.
Okay, great. And then my question, thank you, is for the director, actually. I don't have a lot of experience. I'm in general aware of these risk assessment tools that are used in helping to assess the appropriateness of parole, granting parole. Can you give, but I'm not real familiar how they are used. Can you give us any information on, the assessment tools, how they work, and how they've been validated over the years?
Chris DeRico for the record. So we have a validated risk assessment tool that the parole board has used since 2004. It was revalidated in 2008, revalidated again in 2012, revalidated again in 2017, and it's currently under review right now with our results of the revalidation going to come back to us supposedly next month. And so how the risk assessment works, we consider first the severity level of the crime. Every crime is assigned a severity level from highest, high, moderate, low, and low. So you have one axis. And then you also have a risk level, that we also take into account, which is high, whether the person is high, moderate, or low. In our risk assessment that is done, it's a starting point, and it is the standards as in statute right now is the first tool to take a look at here. We apply the risk level to the prisoner being considered for parole at their initial assessment. And what you'll get is you'll get out of that, bear with me, just go to our actual risk assessment. So we have a bunch of questions, there's a bunch of questions that get us to where we are, where this person falls regarding the empirical data. The static factors that this risk assessment goes through are first, the age of first arrest for the inmate, whether or not they've been revoked before previously under parole or probation supervision, their past employment history, prior offenses or prior convictions to this offense, history of drug or alcohol abuse, and their gender. Those are the static factors of this assessment. Those aren't going to change. From there, we look at the dynamic factors: age, active gang membership, whether they've completed any programs while in the institution, disciplinary conduct, their current custodial level at the institution. And from there, you come up, you get a final score, and it'll place them in the matrix. Will tell you, this tool gives us a recommendation that says either there's a few options. It might come out to deny parole because they score so high on there. It might come out to consider factors, which I'll cover a little bit more here last. It might come out to parole at first or second hearing, or it might come out to parole at your initial hearing. Now, when we get back to the consider factors, parole would be very easy for everyone to do or sit on the parole board and do it if you have a validated assessment that says deny parole. That's easy. We know how this person scores. Much like somebody says parole at initial or parole at first or second hearing. The deviations on those aren't great, but they do happen. But it's the ones where we make our paychecks is the ones that come in the middle, the consider factors. And from there, then after this initial assessment, we go even further and we consider all aggravating and mitigating factors of a case as well. So, and I can give you some examples of aggravating and mitigating factors that we cover. This is above and beyond the assessment. So, whether a prior prison term served by the prisoner did not deter subsequent criminal activity, whether they were convicted or adjudicated delinquent for a sexual offense, whether they're adjudicated or delinquent for violence, is a repetitive criminal conduct, prior criminal history, disruptive institutional behavior, whether or not they scored as a high risk on a separate sex offender assessment, which we also must review prior to any grant of parole, whether they committed a crime against a child or a vulnerable victim or the elderly, if there's any extreme or abnormal aspects of the crime, if they refuse to complete or refuse to participate in treatment, whether they were removed from a correctional program, such as maybe a 305 or 315 program where they were out in the streets as an inmate and they got brought back in, that's another factor we would consider as an aggravating factor. Whether they committed any prior crime while on parole, pretrial, any type of bail, whether they've been in disciplinary segregation before. But I also want to bring up, we consider the mitigating factors of the case as well. And with that, we want to know, do they have no prior criminal history or very little prior criminal history? Whether they've had no infractions previously during their incarceration term? Have they participated in programs? If they've done that, that's a mitigating factor. Have they adjusted positively to a reentry program? Whether they've been previously successful under probation, we take that into account. Do they have a stable release plan? Do they have a detainer lodged against them in another jurisdiction or a consecutive sentence? Is the sex offender assessment a low versus a high? That would be a mitigating factor.
Can I ask that, is this public where you could actually submit this to members of the?
It's all posted on our website, our assessment and the tools on the scoring guide.
Okay, excellent. Thank you.
So, and with that, in a nutshell, we don't just say we don't look at just one thing. There's a lot of, the risk assessment's been in play for almost 20 years, being revalidated again. And not only, that's a starting point, but then we also look at the aggravating and mitigating factors before a decision is made.
And I'm sorry, Jim Hoffman, if I could just follow up to that. So the chairman was talking about the risk assessment tool that's used. Just for the record, our bill would not do anything to touch that. They would still be using this risk assessment. They would still be allowed to consider all of these factors. You know, we don't have a problem with that part of the process. We are not trying to change that part of the process.
Thank you. Our next question is from Assemblyman Gray.
Thank you, ma'am. I wasn't quite ready for that one, but I'll finish it up anyway. So we've heard that about 67% of convicts in prison are violent, have committed violent offenses or sexual offenses. I am really concerned that most of us in society go through life, an entire life without committing a single felony, but yet we're going to take people who already have at least one conviction in prison and presume that, because they've behaved in prison for the last 12 months in a controlled environment, that they're going to be able to be reintegrated into society. So that's just going to lead to my question. What empirical data are you guys looking at to base this judgment on? I think 12 months is a very, very small period in the life of a person that's behind bars for a violent offense or a sexual offense.
Thank you for that question, Jim Hoffman. So we already take into account the fact that people commit violent or sexual crimes. The first way we take that into account is that the legislature sets a harsher penalty for those things. And then the second way that's taken into account is the judge at sentencing can look at this individual person and decide, oh, they're the most violent, I'm going to sentence them at the higher end of the range. So telling the parole board to then also consider this, it's sort of like triple dipping. The function of parole is not to stack more punishment on top of people because they did a bad thing. That's the function of the legislature's laws. That's the function of the judge. The function of parole is to evaluate whether this person has reformed in prison or whether they're going to do it again. That is what we believe the parole board should be focused on.
Madam Chair, follow on, please.
We actually have a few more questions, so I'm going to go to them.
I
and
didn't
then
get my
come-
answer, though.
What was your question?
Question was, what empirical data are you basing these decisions on? You said, we believe.
Okay, excuse me, Assemblyman. So we'll come back to that and give another opportunity. Assemblywoman Gallant?
Thank you, Chair. So, I'm looking at this amendment, and I'm wondering how the validation process would still be in play just through reading this. It seems like Section 3 sort of trumps everything else. So can you kind of conceptualize how the parole board would still be able to use the current measures that they have, and then also how it won't open up to more frivolous lawsuits against the parole board?
Thank you. Jim Hoffman. So this is a presumption that we're creating. And a presumption is just a starting place. To analogize, there's a presumption that you're innocent until proven guilty in our system. That doesn't mean people don't get proven guilty. People get proven guilty all the time in court. The presumption is just with sentencing, it's telling the judge this person is innocent until they're proven guilty. With parole, it would be telling the parole board this person should get paroled unless it's proven that they can't be. And they're allowed to look at anything in making that decision. Chairman Dorico talked about all the different factors they can look at. From my perspective as a defense lawyer, we don't have a problem with the system not being able to convict people. That part of the system functions even though there's a presumption. That's how it would work here. I hope that answers your question. Thank you.
Assemblywoman Hardy?
Thank you, Chair. So part of my question has been addressed just as far as, so I just want to confirm, the parole board, they can only look at the preceding 12 months, previous 12 months, nothing beyond that, and making a decision. That's the first question. And then I wanted to address also, you're changing commission of to conviction of. So that I just want to discuss that a little bit, because I think that's concerning, given those items listed under that. Thank you.
Assemblywoman Shannon Bilbray for the Axelrod for the record. No, the parole board can go beyond the 12 months. That's the first part. And then as far as the commission rather than conviction, to me, it's really simple. It's saying that you've been accused of a crime is the commission, where we're saying it's conviction, but Mr. Hoffman can take it from there.
Thank you, Jim Hoffman. So to answer your first question, the 12 months is just for the presumption. If there are no bad things in the last 12 months, there's a presumption of parole. But the parole board is still totally allowed to look before that and say, oh, there was a bad thing that you did 13 months ago. That is the reason we're using to deny it. So that's just about when the presumption attaches. They are still free to rebut that presumption. And then I believe Assemblywoman Bilbray Axelrod correctly said it. You know, as I said to Assemblywoman Gallant, in our system, we presume that you're innocent until you're proven guilty. We believe that should be true in the parole context as well.
And I understand that we assume innocence until you're proven guilty. Would be concerned that if they're committing any of those things, like violating a protection order or, places they're not supposed to be anyway, especially when you're involving victims and things like that, that's a concern.
Jim Hoffman for the record. So if someone commits a crime or violates a protection order, then they're going to get convicted of it sometime later, a month or two later usually. So that's when they would get violated. They would still get violated. They would just have to go through a judge looking it over and being like, yep, you're guilty. So it would not be such a major change, I don't think.
Chair, may I provide some clarification on that at least from parole?
Quickly?
Okay, so the commission versus conviction, what I see happening with that, the statutes touched in there have to do with parole violations. So in essence, I don't believe that changing that, the Division of Parole and Probation is going to be able to allege a parole violation until they have a conviction. For instance, if someone goes out and commits an armed robbery, a sex offense, or anything else, they don't have an alleged violation if it changes to conviction, because they will have to somehow, some way, either continue to supervise if they're OR'd or released on bail or whatever. They don't have a violation. So that individual quite possibly could still be in the streets, could be supervised, could be sitting in a jail if they were, held in detention. They would not be able to be returned to the Department of Corrections, because right now we have commission. If there's probable cause, they got arrested for some new crime, but until there's a conviction, the Division of Parole and Probation is going to be hard pressed to submit a violation report with that language change.
Thank you. Our next question is from Assemblywoman LaRue. Hatch.
Thank you, Chair. So I just want to kind of bring together the many questions that were asked and just confirm a couple of things. So one, you said that this brings a presumption of innocence to this select group of people that haven't had any issues in the last 12 months. Does that mean that currently there is not that presumption, that the presumption is parole will be denied unless you prove your way out? And then along with that, it sounds like we can still consider all the factors that they are currently considering. So what would actually change in the day-to-day process with this new language?
Jim Hoffman for the record. Thank you for that question. So our concern, let me start with your first question, I guess. There is no presumption, there's no formal presumption either way right now. Our concern from talking to inmates, there seems to be a sort of informal rule where the more serious an offense is, the more people should just expect to get their parole denied. Chairman DeRico talked about the risk assessment spits out an answer sometimes of parole on your first or second hearing. And what that means is we're not going to grant you parole now, we're going to deny it, come back in a year or two. That can be a problem because it might not be the same panel of people in a year or two. So those people can say, oh, I think you need to do more anger counseling. Come back after you've done anger counseling. That person expects parole, but now it's a different panel or someone new has been appointed to the board, so they're getting a different result. And they're getting denied again based on the nature of the offense, even though they've been working hard to do what they're supposed to be doing. So what this would change is that it's just sort of, I guess I would phrase it, it's directing the parole board to not put so much weight on what the offense was. They would still be allowed to consider that. They would still be allowed to consider the person's conduct. It's just sort of a tweak to make it so that this triple dipping is less likely to happen.
Next question from Assemblywoman Newby.
Thank you, Madam Chairwoman. I was curious about the new language in Section 2, subsection 11, regarding the recommendations to improve the possibility that they would be paroled at the next hearing. Could you give an example of what kind of direction is given now and what sort of direction would be hoped to get or be provided to the inmate with this change?
Thank you, Jim Hoffman. So that is more of a conforming change. Under existing law, the parole board is already required to explain why they're denying parole. And so this would just be sort of giving people written advice on what they could do to improve their score on this risk assessment. So this, from our perspective, that's not really a substantive change. We changed the presumption, so we want to tell people about that.
Thank you for that. Next question from Assemblywoman Summers Armstrong.
Thank you, Madam Chair. Thank you for the presentation. During COVID, a lot of programs were suspended because of COVID. Can you talk to us about what happened to those folks who were eligible or should have been eligible, who were not able to participate in their programs? Did you make any special accommodations for those folks, or were they just denied parole because they couldn't participate?
Thank you for that question. So what happened is everything that was done previously continued to happen. They continued to have a risk assessment done. It was the first step in going there. And if they were not unable to program, our commissioners were very cognizant of that fact. And because it is factual, there were a lot of programs that individuals could not attend to better themselves. And if they couldn't attend those programs, what was going on, we made sure that we looked at that in relation to where the assessment would have been had they been in that program or where they wouldn't. And for the record, the score on that assessment, if they were in and completed a program, they would get a -1 on that assessment if they had completed programming. And they didn't, they get 0. So they were not negatively or adversely affected by not completing the program, but we knew if they were there and they were on the cusp, for instance, if they were on the cusp of a grant parole versus consider factors, we took that into effect as well. And additionally, during COVID, when we had this happen, we were shut down essentially to the public for 2.5 months. However, for that 2.5 month period, commissioners went through every file by hand to go through and try and determine who we could grant in absentia for a 2.5 month period. And for that 2.5 month period, we had a 100% grant rate. Why? because statute says we cannot deny parole in absentia. So even though we were closed and our hearings have to be open to the public, we wanted to find a way to continue doing our job that we were supposed to do, to look at and to get as many people out as we could, and we did just that.
Follow-up, please.
Quickly, please.
Thank you. So you just gave a numerical definition, -1 for a program. How many points total are in your assessment? And if you're only getting -1 for completing a program, how high is this bar of for people to even be able to get enough points off for them to make this even worth their while, to try to comply with going through all these rehabilitative processes? Thank you.
Yes, thank you for that question. So the bar, if I had to ask for in here, is the maximum amount of points someone could have is 19 points. Okay, that would be the maximum. That's somebody that would be a clear deny. We don't see 19 points. So what I can tell you is, and if you'd like, and I think we're getting here, I can kind of, do you want me to break up the scoring for each of those 7 static? No, okay.
No, sir. Just give it a broad understanding, if you don't mind.
So the broad understanding is, if I can break down, the maximum is 19. You could potentially have negative points. Once again, we don't see that either. With the risk assessment, if you score 14 and above, you come out as a high risk according to this validated tool. If you score between 8 and 13, you're a moderate risk. And if you score between 0 and 7, you would be a low risk. And so those are the scoring for the risk level in the 3 separate categories.
Okay, thank you. We will return quickly to Assemblyman Gray for his question.
Thank you, Madam Chair. Again, what empirical data are you basing the 12 months on that these inmates will be returned to society any better than any other period time frame?
Shannon Bilbray Axelrod for the record. So unfortunately, we don't have a crystal ball, but I think that in the state of Nevada, the idea is that we do rehabilitate people and we do want to get them back into society. We don't just want to put people in a cell and throw away the key. That's not what we do. So most of our information is anecdotal because people are different. But we do know, and we've had many conversations with the Department of Corrections, and I'm so pleased that Chief Dorico is here. I knew that everything coming from Chief Dorico's mouth wasn't going to 100% back, what I was saying. I want to have this robust conversation, but the goal of this legislature, I believe, and the goal of the state of Nevada is to rehabilitate people. So, like I said, we don't have empirical evidence because all people are different, but we're just trying to do the best we can.
And if I might follow up, Jim Hoffman for the record, I would lean heavily on the experience of other states. So 17 states, also the federal system, just got rid of parole entirely. They think it's too much discretion. It should only be judges deciding when someone gets out. We don't want to go that far. We think that the parole board does mostly good work. There are these other 7 states that have said parole should be presumptive, but the parole board should still be able to deny it if they feel that it's warranted for a given offender. And so that's where we think the best balance is. And we think there are 24 other states that are already doing this. We would be number 25. We think that their empirical experience is helpful in that regard.
Thank you so much. And with that, I'm going to go ahead and open it up for testimony. I believe that there are many people that, by the amount of folks in the room, that would like to testify, so I'm going to ask that we keep our comments concise. And I will first open it up to testimony in support of Assembly Bill 229 here in Carson City.
Good morning, Chair, members of the committee. Erica Roth, Ericaroth, on behalf of the Washoe County Public Defender's Office, here testifying in support. This bill sets a uniform standard for everyone who's looking at who is going to go up for parole, if or they should or should not be released. What's important to note is that the goal of parole is to continue the process of rehabilitation of offenders and guide them back into society. It's not a punishment, it's a tool in rehabilitation. And when done right, parole can reduce prison costs and reduce crime. There's been some questions today about data. So the Pew Charitable Trust, a nonprofit organization, found that parolees can be 36% less likely to commit new crimes when used correctly. Parole, again, is a tool in rehabilitation. And then I just want to touch on some other questions that came up. When we're talking about committing a crime, the commission of crime versus conviction of a crime. When an individual, for example, gets into a fight in prison, that's a Category B felony, battery by prisoner, right? It's not a little thing. If an individual violates an extended protection order, if they call the victim of a sexual assault, that is a Category C felony. They will be held pending determination of guilt on those charges. So it is not a situation in which someone is released just because there is no conviction yet. And that's really important to note. So when we're thinking about what this bill does, it sets uniform standard. It says that a person who is not getting in fights, who is following what they're supposed to be doing, they get a presumption that they should be released, but so many things can still be considered, and that's why we think this is good policy. Thank you.
Thank you, Madam Chair. John Puro for the record, JOHNPIRO from the Clark County Public Defenders. I do just want to echo some of the colleagues of my colleagues, Ms. Roth and Mr. Hoffman. One of the things that's very important for us is the commission versus conviction issue here. If you get accused of a new crime while you're out, you are going to be held on either a parole hold or a probation hold. You're not going to be released to the street unless it's under very extreme circumstances, like the DA's case is very weak, and we could show that in a bail hearing. In some instances, you're pulled all the way back to the prison to go before the parole board before you're convicted of a new crime. So we could go to trial on this new offense, win, get a not guilty, but frankly, you were waiting in prison for a year or more for your trial. So the difference between commission and conviction is kind of a big deal, and so we're very thankful that Assemblywoman Bilbray Axelrod is bringing about this change. I think this is a much needed change in our statutes. Thank you.
Good morning. Excuse me. My name's Jody Hocking, JODIHOCKING, the founder and executive director of Return Strong. In our work, we work specifically with people who are currently incarcerated and their families on a wide variety of issues. One issue that our members regularly write to us about, we had almost 200 letters in the past year specifically on this issue around parole boards, is the parole board process. While we understand that parole is presumptive, or is not presumptive, and everyone understands that they don't have a right to parole, the entire process has always been mysterious and unclear for people who are incarcerated and their families. This bill, we feel, would really address some of the major issues with the process and take huge steps towards a more equitable system that encourages people to focus on preparing for parole and life after prison. Currently, it seems like there's no rhyme or reason to who gets parole. Obviously, there is some, but doesn't always feel like that. There's no communication with people so that they even know why they were necessarily not granted. And they go to the parole board sometimes with zero institutional behavioral issues, but they'll come back on a violation or a technical violation, and that requires them to get dumped. They don't get parole, even if they were doing everything right while they were incarcerated. Hope is a powerful motivator, and losing that hope can change the trajectory of one's life. In the case of parole, it isn't just the person in prison that can lose hope, but families, children, mothers, fathers, wives, and husbands. Today, if I don't run out of time, I want to tell you a quick story about a family that we have worked with, who the father was actually incarcerated prior to the daughter's birth. And I remember I helped with visitation for this family for a long time. And he came to a parole board when she was 8 and was denied, and she could not understand. She cried and like for months was like in a depression. And I remember sitting down with her one day and talking to her and explaining she had just gotten in trouble with her grandmother for something, and her grandmother grounded her for longer than she felt was necessary. And I had to try to break down like why he didn't get parole into something that a child could understand. He didn't end up actually getting parole. He didn't have any issues while he was in prison. He was doing his sentence, but by the time he came home, she was 12, almost 13. And the impact on that family is that family relationship still is not repaired. And she's now pregnant and 15 and in the care of DCYF and still looking for her father. And so I just want to provide another side of this, is that we can destroy hope sometimes with risk assessments and I understand the need for those things, but I just want to remember that there's a human side of this outside of that, and I could give you 185 stories today, but I'll leave it at that one. Thank you, and we are in support of Bill AB 229.
Thank you so much. Is there anyone else here in Carson City that would like to testify in support? Not seeing anyone here in Carson City. The phone number is 1-669-900-6833, and today's meeting ID is 870-901-57838. Broadcasting, will you please open the line for anyone that would like to testify in support of Assembly Bill 229?
To testify in support of Assembly Bill 229, please press star 9 now to take your place in the queue. Again, to testify in support of Assembly Bill 229, please press star 9. Chair, there are no callers choosing to testify at this time.
Thank you. With that, I will open it up for testimony in opposition of Assembly Bill 229. Again, I ask that you state your name clearly for the record and spell it. And again, let's keep it to brief to like 2 minutes.
Good morning, Madam Chair, members of the committee. Adam Cate, C-A-T-E, on behalf of the Nevada District Attorneys Association in opposition to this bill. The District Attorneys Association disagrees with the premise that the factor of the inmate's performance during the last 12 months in prison should be granted superiority over the remaining factors in determining whether someone should be granted parole. Of the nearly 30 factors that it's considered by the parole board, it's simply one factor. I don't think it's triple dipping for the parole board to consider factors related to the crime and the person's previous supervision, how they performed, whether they're on parole or probation in the past, and determining whether they should be granted parole again. Really, the job of the parole board is about the risk that an inmate poses to our community. And they've told you today that they have a validated risk assessment tool that they've used for the last 20 years to determine the inmate's risk to the community. And the District Attorneys Association believes that that is the best method for determining the risk that they pose and whether or not they should be granted parole. Additionally, there was discussion about how the judge sentences, and that's when we consider many of these aggravating factors. That's not always the case. It's my opinion that the judge sentenced the maximum, and then it's the parole board's decision on whether the person should be released once they're eligible. But many crimes, sexual assault, lewdness with a child, sexual assault upon a child, the judge has one option, either 10 years to life for lewdness or sexual assault. They don't get to determine the sentence. And so it's up to the parole board to look at the facts and circumstances of that crime and determine whether parole is appropriate or whether this person should remain in prison for a longer period of time based upon the facts and circumstances of the crime. Additionally, the District Attorneys Association, also opposes the changing the non-technical violation definition from commission to conviction. It increases the standard for revoking someone's parole from essentially probable cause to now proof beyond a reasonable doubt. And additionally, it places the conviction of another crime or the commission of another crime is now more difficult to prove than other parole violations, which are less serious. So more serious, more risk is more difficult to prove. And then we just also disagree with the timing situation, and we think this is going to lead to a long delay in people's parole being revoked if this change is adopted. With that, we oppose the bill. Thank you.
Thank you.
Good morning, Chair Miller, members of the board. Greg Herrera for the record, G-R-E-G-H-E-R-R-E-R-A, and I represent the Nevada Sheriff and Chiefs Association. I'd like to say everything that he said, but I'll just sum it up quickly. We also have some of the same concerns. As been stated in this hearing and in previous hearings, that parole is an act of grace. But the presumption of parole simply based upon 12 months following the rules, which in many cases is just a small fraction of the time being served, does not equate to an act of grace. We believe that this could also provide for unsafe conditions for NDOC staff, with inmates knowing that they're not on the clock for being held accountable until the final 12 months leading up to parole eligibility. Presumption of parole may also discount the significance of victim impact statements at the time of the patrol hearings and reduce them to irrelevance. Victims often spend a lifetime trying to heal from crimes committed against them, and their statements should continue to be considered by the parole board. We also believe that the language from commission to conviction will have a significant impact on jail populations for our local jurisdictions. Parole violators will be months waiting in county jails, waiting for a trial to be sent back to NDOC for these violations. For those reasons, we're asking that you oppose AB 229. Thank you.
Good morning, Chair Miller and committee members. Adrian Hunt, A-D-R-I-A-N-H-U-N-T. Police Detective representing Las Vegas Metropolitan Police Department. We oppose AB 229 as written for the reasons of my colleagues have mentioned before me. We are particularly concerned about the technical violations. Jim Hoffman said the time between commission of a technical violation and conviction would be a month or two. I need to rebut this. In Clark County, the time frame between commission and conviction of a technical violation could be months or years. It most definitely would not be a month or two, and while a person is awaiting the decision, they would be housed in county jails. This process would cause population issues and fiscal impact for our local jails during the process of this technical violation. We are opposed of AB 229, but look forward to continue to work in concert with Assemblywoman Bilberry Axelrod. Thank you.
Good morning, Chair Miller. Good morning, members of the committee. Jason Walker, Jasonwalker, Washoe County Sheriff's Office. I echo the comments of my colleagues. Director DeRico clearly explained the factors in use for granting parole. It is my opinion that's an above and beyond look other than a standard, and I am testifying in opposition on behalf of the Washoe County Sheriff's Office for AB 229.
Thank you. Is there anyone else in the room here in Carson City that would like to oppose the bill? Not seeing anyone? Broadcasting, please open the lines.
To testify in opposition to Assembly Bill 229, please press star 9 now to take your place in the queue.
Hello?
Hi, we can hear you.
Hi, I apologize, but I'm in favor of the bill. And is it all right if I make a statement because we were not able to get through?
Yes, we understood that you had some technical difficulties, so I will accept your We are in opposition, but I will accept your testimony right now. Please proceed.
Okay, thank you. My name is Robert Stossmeyer, RobertStockmeier. I would like to thank this committee for bringing such an important piece of legislation. The ideas behind this bill demonstrate the progression of a maturing society through continued criminal justice reform. This bill reflects the appropriateness of fairness for those who have already served very tough sentences under Nevada law. I know, I was there. I went to prison in 1990 after a guilty plea to sexual offenses I committed when I was an emotionally and socially immature 21-year-old. I'm now almost 55. Being in the military in a small town near election time, I was sentenced to 2 consecutive 10-to-life terms, which shook a community. Upon entering the prison system, I immediately sought counseling. I wanted help. In those days, the then Department of Prisons offered intensive sex offender programs of a whole different nature than just reading from a book. They were intense and life-changing, so I participated in these programs for 18 years. Throughout my 30 years of incarceration, I was a textbook model prisoner. I took all kind of programs in high schools and Pell Grant, and I took college until the Pell Grant expired. And I remained employed for 22 years, working as a psychology department clerk, a law library researcher, a sewing machine operator, and apprentice prison industries clerk. Over the course of 3 decades, I received a single minor write-up. I developed and facilitated courses for the psychology department, including social skills, arts and humanities, and other classes. The parole board went on to recognize the value of these programs by deducting points from inmates' risk assessments for completing these very programs, which I developed. I became eligible to be paroled off my first life sentence and start my second one in 2000. Notwithstanding my accomplishments and growth, the board saw fit to deny parole to me in 2000, 2003, 2006, 2008, and again on rehearing in 2008. On the rehearing from the rehearing, the board finally allowed me to move on to my second life sentence in a peculiar order which granted parole 13 months later. The consensus seemed to be that parole board did not deem 19 years sufficient on a 10 to life, even with another one to go. Upon my first appearance for parole consideration on my second life sentence in 2020, the board granted my parole. Over the past 3 years, I have flourished in this society, and my life demonstrates that the 10 extra years I served were not necessary. While I have tremendous respect for the parole board and the often tough decisions it must make, I have never been able to fathom any just reason for repeatedly denying parole to a prisoner, doing everything right and with a consecutive life sentence yet to serve. I could never grasp how this prolonging of punishment reflected the grace with which parole is to be administered. It is not logic, it seems like.
Sir, I'm going to ask that
Yes,
you wrap
ma'am.
up. I'm going to ask that you wrap up your testimony, please.
Okay, yes, ma'am, thank you. This bill would remedy such imbalances and would not only create a standard of fairness for all prisoners who seek parole from lengthy sentences, but would also provide some certainty and clarity for the families and the victims. Thank you very much.
Thank you. And we will move back into opposition. Broadcasting, is there any additional callers?
Chair, there are no other callers choosing to testify at this time.
Okay, thank you. With that, I will open it up to testimonies in neutral for Assembly Bill 229.
Good morning. Tanya Brown, Advocates for the Inmates and the Innocent, spelled TONJABROWN. We are here today in neutral. We do echo the comments made in support. The reason we are in neutral because we would like to see some changes made to the bill. Under Section 1, 3A and 2, we ask that the change the language that constitutes a felony to new language convicted of a...
Excuse me, Ms. Brown,
Yes.
according to the committee rules, anything, unless you're accepting the bill as written, if you have anything against it, it's actually opposition. So if you're asking for amendments or changes, it would be in opposition. So would you like to change your testimony? Or would you like to submit your amendment suggestions to the bill sponsor?
I would like to change it to opposition. Can I do that?
Continue.
Then I can continue. Thank you very much. I thought maybe a neutral because I do agree with it, but I just want to add additional language to it as well.
Again, those
Okay.
are the committee rules, so
Alrighty,
it's
I'm
not
sorry.
100%,
Thank you
so
very
we're
mu-
going
I'm
into
very sorry.
opposition.
Thank you. Okay, so we would like to change the language that constitutes a felony to the new language convicted of a felony. We base that on the inmates that will wind up getting a disciplinary action will be submitted in their file, submitted to the parole board, and the parole board will not know that the inmate have filed suit and won, and it should have been removed. Also, under section 1 of the subsection 4, we would like to include new language right after the board shall provide to the convicted person a written statement of its reasons. To include the new language, the board's written reasons must be defined and delineated other than a threat to society, heinous crime, the nature of the offense is their standard practice to use. Threat to society, the nature of the offense must be defined. These are reasons the board can use to overcome the presumption to grant parole. And that is a huge thing. They will come in and they say, reason to deny, threat to society. They don't say what the threat is or the offense. Again, it was spoken earlier. The parole board is there to see what they have done. The jury makes the decisions. The courts on the guilt. The judge carries it out. If they have a life with the possibility of parole, they should be granted it. And a lot of times they're not, because the parole board relitigates the case, and they should not. They are there to see how well they are doing in prison and base it on that, not retry the case. Thank you.
Thank you. We will move back into neutral testimony.
Good morning, Chair Miller. For the record, Harold Wickham, W-I-C-K-H-A-M, Department of Corrections, Deputy Director. My colleague beside me is the Chief of Offender Management, Kurt Widmar. And thank you, Assemblywoman Bilberry Axelrod, for your bill. Our only concern would be just specifically that the NDOC typically doesn't charge felonies if an offender gets in a fight, assaults another offender. We don't charge them with a felony specifically. We could, but it goes through the Attorney General's office and then through the courts, which would absolutely bog the systems down to a complete stop. So we use an administrative process to do that. So our concern would just simply be the language, if that could be modified. We're happy to work with staff, the bill sponsor, and all the stakeholders for that. So again, we're testifying in the neutral, and we thank you for the opportunity.
And thank you for that clarification.
Good morning, Chair and members of the committee. I am Aaron Evans, A-A-R-O-N-E-V-A-N-S, Deputy Chief of the Division of Parole and Probation, here to testify neutral on this bill. In my conversations with Chairman DeRico, this bill will increase the rate at which individuals are granted parole, and by doing so, I simply want to make you aware of the impacts on the division and our operations. With the effective date of this bill as written, the additional parole grants and reentry plans that this will generate will add to the workload of my existing pre-release staff and supervision staff across the state. These positions are responsible for coordinating the releases and processing the releases to places that are going to set these individuals up for success and foster rehabilitation all the way through the end of their parole supervision. To adequately handle the increased number of parole grants, the division will need new positions created, recruited for, background checked, hired, and trained, which can take months to even over a year. Adding more people to the parole queue before having the necessary personnel in place to process the releases will result in a greater amount of time between parole grant and parole release, and the number of individuals incarcerated past their parole eligibility date will likely increase. Until enough sworn positions can be hired and trained, which, like I said, can take over a year, supervising the increased number of parolees will be challenging and the rehabilitation efforts will be impacted. If the division is able to hire and train and retain individuals to fill these positions prior to the enactment of this language, then these impacts could be mitigated. Thank you.
Thank you for that.
For the record, Heather Proctor, Heather, Procter. Chief Deputy of the Post-Conviction Division of the Nevada Attorney General's Office. I would like to preface this by saying we have some concerns regarding the policy and implementation of AB 229. But my testimony...
Excuse me, so are your concerns, are you testifying in opposition then?
No, we're testifying in neutral.
Okay.
Regarding just some general concerns that we have.
Impact on the agency? Or do you need to shift into?
Thank you so much. I think to answer that question, Chairwoman Teresa Benitez Thompson, Chief of Staff for Attorney General Ford's office. So our discussion is on, we aren't going to speak to the policy, we just want to speak to policy implementation. So what this will look like on the back end moving forward if passed as written.
Please, thank you.
And I apologize for that confusion. To put my testimony into context, my division litigates any inmate challenges to time calculation as well as the denial of parole. Our concern is with the presumption of parole that it actually creates a liberty interest, which creates a right to parole and undermines the act of grace that exists in our state statutes. The second concern that I'm going to testify, as we are running out of time, is that in Section 2, it does specify that the board must give specific reasons for denying parole. Our concern is if one of those reasons is victim information, that could potentially undermine victim confidentiality if it has to be listed specifically, and it could potentially put victims at harm. Thank you.
Good morning, Chris DeRico, Chairman, Board of Parole Commissioners. Since 2017, Nevada's prison population has been declining. In fact, it's at its lowest level since 2001. Approximately 85% of the prison population right now consists of Category A and B felony inmates. Category A felonies apply to individuals sentenced to death or imprisonment for life or life with or without parole. Some of these crimes include murder, kidnapping, sexual assault, child pornography, lewdness with a minor under age 14, and habitual criminal. Category B felonies apply to individuals who've been sentenced to not less than 1 year nor more than 20 years imprisonment. Some of those crimes include voluntary manslaughter, robbery, assault with a deadly weapon, sex trafficking, possession of a firearm by an ex-felon, arson, luring a child for sex, and DUI causing substantial bodily harm or death. So 85% of those are made up of similar type cases right now. The amended language in this bill provides for a presumption in favor of granting parole if an inmate stays out of trouble for the 12 months prior to the parole hearing. This language contradicts our validated risk assessment and does not appear to be based upon empirical analysis or statistical research.
Sir, is this in neutral?
Yes.
About the impact on the parole board?
I'll strike that. I'll strike. We don't need. I'll remove that. We are in neutral.
Okay. Would you like to share any impact on the parole board?
Yes. So the impact on the parole board is, in 2018, Marcy's Law was overwhelmingly passed by the voters and was added to the state constitution. It allows the victims to participate and provide information to the parole board and to have the safety of the victim and the victim's family and the general public considered before any parole release decision is made. If this bill is passed, we'll continue to provide those rights to the victims and educate them that the presumption of a parole may result in a grant unless it can be rebutted with specific reason. This will move the board away from what has been our primary mission, focusing on public safety and successfully reintegrating offenders back into the community, but we will adapt to any legislative changes. And lastly, I want to, Mr. Hoffman mentioned previously that there's no appeal rights for somebody that's denied parole. That's false. We do have appeal rights, and they're in our regulations. Thank you.
Thank you. Anyone else here in the room that would like to testify in neutral of Assembly Bill 229? Broadcasting, is there anyone on the line?
To testify in neutral for Assembly Bill 229, please press *9 now to take your place in the queue. Again, to testify in neutral for Assembly Bill 229, please press *9 now. Chair, there are no callers choosing to testify at this time.
Thank you so much for that. With that, I will bring up the bill sponsor for any final remarks.
Assemblywoman Bilbray Axelrod, for the record, thank you for hearing this bill. As I said in the very beginning, I realize that the opportunity for parole is an absolute act of grace, and the impact to the victim should absolutely be considered in every hearing. I thank Chair DeRico for being here. I kind of asked around if anybody was aware of the appeal process. I guess you can write a letter, but we're not aware of any time that that appeal has been overturned. This is an important bill. It is, and I know none of you will take this lightly. I mean, we are asking that the state of Nevada gives people a chance. As my co-presenter mentioned, this is the way that it's going, that we would be the 25th state to have this presumption of innocence. And I think we all know, as he said, innocent till proven guilty, just to be able to go in when you're doing the right thing. And I urge my colleagues and everyone to look at the letters that have been submitted, where people are really, really trying to turn their life around in prison. And I just believe that the state of Nevada should recognize that. And when Chief DeRico said you get a -1 for doing those things, that just doesn't seem like enough when you're actually really trying to make a difference in your life and trying to rehabilitate yourself. So I thank you. I think Mr. Hoffman wanted to address just a couple of things, and then I just thank you for hearing the bill.
So the first thing I wanted to address, we are, Jim Hoffman for the record, sorry. We are in ongoing discussions with the various institutional actors who've testified. Actually, there will be at least one amendment forthcoming. We have spoken with the NDOC. We're going to address their concerns, working with the other actors. The other kind of big picture point I would make, there's a carrot and a stick in the criminal justice system. And the stick is prosecution, the stick is prison time, but the carrot is the hope of parole. And that carrot is important because that's what encourages people to work, to address their problems, to deal with the reasons that they committed the crime in the first place. And that's a really important part because that's what ensures that they don't commit that crime when they get out. So that hope of parole needs to be meaningful and consistent, and we believe this bill will get us there. Thank you.
Thank you so much. And with that, I will go ahead and close the hearing for Assembly Bill 229. Our next bill is Assembly Bill 275. It will be presented by Assemblywoman Hardy and Lisa Mosley, the State Director of the Fines and Fees Justice Center. Assembly Bill 275 revises provisions governing the sealing of criminal records. So we're going to give them a few minutes as the room is in transition and our presenters are getting ready. And the hearing is officially open, so Assemblywoman, whenever you all are ready, just please feel free to begin.
Good morning, and thank you, Chair Miller and members of the committee. For the record, I am Assemblywoman Melissa Hardy, representing Assembly District 22 in Clark County. I am here today to present Assembly Bill 275, which revises provisions governing the sealing of criminal records to victims of sex trafficking. And I'm pleased to have Lisa Mosley from the Nevada Fines and Fees Justice Center presenting with me today. Early in my time as a lawmaker, I had the opportunity to meet and hear the stories of victims. Their bravery and strength astounded me, but I was also struck by some of the more modern inconveniences visited upon them as they worked to rebuild their lives. In the 2021 session, I worked on Assembly Bill 113, which extended the statute of limitations for prosecutions of sex trafficking crimes. That bill, like this, was a practical, common-sense policy done in a bipartisan fashion. It is my belief that good policy knows no party affiliation, and we can tackle these issues as lawmakers with no daylight between us. In preparation for this session, I knew that I wanted to build on the work that I had done in this area in 2021. I had the privilege to work with several coalitions, including the Nevada Policy Council on Human Trafficking and also the Shared Hope International, to discuss and determine some policy recommendations they thought would be beneficial and that advocates wanted to see brought forward. And this bill is a result of that work. Assembly Bill 275 is a small step forward, but the foundations of justice for victims are built on small but meaningful steps, things that taken as a whole constitute a picture of our society fairer and more just for those most in need. These are the small obligations we have toward those who have lived too long with shame and in the shadows. The opportunity to rebuild their lives, free of as many obstacles as we can practically remove. I wanted to just share some statistics with you which I believe might give some context. It is estimated that 3.8 million adults and 1 million children are trafficked for forced sexual exploitation per year. Now that is larger than the entire population of the state of Nevada. Of those, women and girls are disproportionately affected by human trafficking, representing more than 70% of all victims. According to the State Department, there are as many as 27.6 million victims worldwide at any given time. The number of perpetrators facing punishment for this crime increases every year, but the number of victims show less fluctuation. Many of the victims may not have homes or communities to return to. They need the necessities, food, clothing, a roof. Their trauma can be prolonged, and resulting disabilities are common. Post-traumatic stress disorder, anxiety, depression, shame, alienation, disorientation, and more psychological disturbances are also common. These victims have been robbed of their confidence and self-worth. The road to recovery is very, very long and largely unimaginable for those of us who haven't lived it. We as a society are getting better and learning more every day, but much work remains to be done, and I believe that AB 275 is one more step down the path, another step toward justice for victims. And I'd like to turn the time over to Ms. Mosley for her remarks, and then I will go through the bill. That's okay.
Thank you, Assemblywoman. Thank you, Chair Miller and committee members for hearing this very important bill. And I want to just thank Assemblywoman Hardy for the honor of presenting with you. This is a very important piece of legislation for us. And in our work at the Fines and Fees Justice Center with fee elimination, Deputy State Director Nick Sheepak and myself have found that we've worked with people who have been impacted by fees. We've had the opportunity to work with people in our work and have learned that these ubiquitous fees are prohibitive and prevent people who have had interactions with the criminal legal system, in many cases, from getting their lives back on track. We've seen fees in all kinds of ways in the criminal legal system. And again, they're harmful and they prevent people from getting their lives back on track in many ways. When it comes to fees to seal criminal records, these fees range anywhere from $150 to $300 in many cases. They present obstacles for someone who is trying to get their life back on track and have their records sealed. And a criminal record can prevent individuals from getting a job, from obtaining housing in many cases. As you all may know, prior to 2013, there were no laws against sex trafficking here in Nevada. Anyone suspected of illegal sex work was simply turned over to the federal government for federal law enforcement prosecution. This included women, girls, and in many cases boys who were being trafficked. Today, these victims probably would never be prosecuted thanks to our state enacting laws against sex trafficking. And though Nevada now has stricter laws in place that protect the women, girls, and young boys and men who otherwise would fall victim to sex trafficking, there are victims who have criminal records that stem from a time when we had no laws in place. They are faced with being victimized a second time by having to pay these fees to seal their criminal records, records that stem, as I said, from a time when there were no laws against sex trafficking in the state. In recent years, our state has committed all kinds of resources in the form of task force with law enforcement, funding, stricter laws, and educating our communities on the perils of sex trafficking. I think we should make one of those resources eliminating fees for victims to seal their records. I think that being trafficked has cost them enough already, and as the Assemblywoman said, in many cases, their confidence, their ability to exist and coexist in society. So let's do the right thing. I remember asking Assemblywoman why she wanted to bring this bill forward, and she said it is the right thing to do. I think these victims have paid enough, and I also agree that it is the right thing to do. So with that, I urge you to move this bill forward, and let's put some additional resources in place to help these victims begin to turn their lives around. Thank you.
Thank you, Ms. Mosley, for working with me on this. So now I just want to go through AB 275. So it's basically Section 1, Sub 9. So this would prohibit a court or agency of criminal justice in this state from charging any fees related to the sealing of a criminal record if at the time the crime for which the record to be sealed was committed, the petitioner was being sex trafficked. And if you look at Sub 9 there, as used in the subsection, fee includes any fee to file a petition, obtain any records of criminal history, obtain records of past arrests and convictions, or obtain or certify copies of documents. And we did include a fee for fingerprinting if it was provided by a governmental agency of the state. So that is our presentation, and we will be happy to answer any questions. Thank you.
Okay, thank you. Our first question from Assemblywoman Cohen.
Thank you, Chair, and thank you for the presentation. So I had this in my notes, and I was listening, and then I saw this in my notes, and so I want to make sure. Sometimes there are convictions that aren't that are terms that people know that are related but aren't for like loitering, right? We all know that loitering is in the past has been used when they're instead of a conviction of prostitution, that type of thing. So is this, I just want to make sure, are we covering previous convictions, especially pre-2013, for loitering or those types of convictions? Is that covered by this bill?
Melissa Hardy for the record. So, and legal may be able to answer this better for me, but in the bill it refers to NRS 201-300, and I believe that is covered in that, but we can verify that.
And thank you for that. I had that circled in my notes to look up and hadn't looked up yet, so thank you.
Lisa Mosley. So what we asked for in the bill was that during the time period that a victim was being trafficked, any crime that may have been committed during that time that is included in a criminal record, we're asking for those crimes, that record of those crimes to be sealed.
Thank you for that. Our next question is from Assemblywoman LaRue Hatch.
Thank you, Chair, and thank you for bringing this important issue. So
my question has to do with the sealing of these records. I agree with you that we shouldn't be charging a fine. I agree that these are victims and we should protect them. Have you considered making it automatic sealing for victims of sex trafficking?
Melissa Hardy, for the record, thank you for the question. I know there are conversations going on about that as a whole. This was just something that I thought that, we could put into practice right away to at least get this ball rolling and eliminate, a huge hurdle. As Ms. Mosley said, sometimes these fees can be hundreds of dollars, and having worked in the Justice Court before myself, and, it's quite a process, as has been explained many times, and so we just felt that this was one way we could just get this started, but, absolutely as those conversations are had, going in that direction would be wonderful.
Lisa Mosley, that would be awesome, actually. We would love to do that. I don't know what kind of obstacles would be presented in making that argument and writing that legislation, but I think it would be amazing if we could do that.
Thank you. Assemblyman Gray?
Thank you, Madam Chair. First, I just want to tell you guys thank you for bringing this forward. This is something that's troubled me for quite a while, that, we continue to re-victimize these, I don't want to say ladies, but these people that are, caught up in this. And, I actually agree with Assemblyman LaRue Hatch. I mean, I'd thought about it, but I just don't see any mechanical way that it can be achieved. But, I guess my question is there something more we can do to help these folks out?
Melissa Hardy, for the record, thank you, Assemblyman. And yeah, I agree. I think we collectively would like them to be automatic, but again, that may take time, and how, what goes into that process of being able to do that. And again, we wanted something that could be done, pretty expeditiously, pretty quickly, to assist these victims. And so, I would encourage you to, number one, support this legislation. I think that's the first thing we can do here, and then be a part of the conversation as we talk about the automatic sealing of records for victims and other folks. But I think the more that we take the steps that are available to us now, that can be done, implemented, in a short period of time, that's the greatest thing that we can do to help these individuals. Thank you.
Thank you, and I love that, Assemblywoman. First, please vote for it. With that, we have a question from Assemblywoman Summers Armstrong.
Thank you, Madam Chair. Thank you, Assemblywoman Hardy and Ms. Mosley, for the presentation. It is so sad. I'm just going to say it's very, very sad that we're in this situation, but it's wonderful to see that you are bringing thoughtful legislation to help our community hopefully improve and bring the light into an issue that we've been pretending didn't exist for a long time. So I have a question with a follow-up, and it's really about process. So how would the agency that collects these fees know that your client or this citizen falls into this category, so that they can get this this grace, right? I'm concerned that I don't want someone at the counter at district court talking about I need to file, seal my records, and someone behind the counter, well, what happened, right? I don't want that person to have to be embarrassed again. So if you could talk about what they would have to present and how this would actually work in reality.
Lisa Mosley. So ideally, well, let me just say this. I understand from some folks and attorneys that I know and people who I've worked with in this process of record sealing fees. First of all, it is a confusing process. It is a lengthy process. There is nothing easy about it. I've talked to attorneys who say sometimes they don't understand the process. But what I do know is that there is a declaration that a petitioner fills out when they are filing to have their record sealed. It includes, I think, why do you want your record sealed? What have you done in that process to be eligible? Why should you have your record sealed? I think it would be easy to include in there just a declaration that I have been a victim of sex trafficking, and this is why I would like to seal my record. That's not something that they have to say publicly to anyone. It's just part of the packet that comes with the petition to seal a record, just including that little paragraph in there. It also will speak to truthfulness. I think there may be some concern about, well, how do we know someone is a victim of sex trafficking? The statute lays it out, but having just that little paragraph included in that packet, in that declaration, I think will go a long way. I hope that answers your question.
Yes, please.
Thank you. So then this raises my second concern, and that is the length of time. If someone is, and maybe this is not the question for you, but I'll just state my concern. If it takes a year to seal records, and we have a person who's been trafficked and they're trying to turn their life around, if you can't get a job, everything is prohibitive, we're opening up a situation where we're forcing a person to go back to a life possibly that they didn't want in the first place because they don't have any options. Remember, this doesn't exactly show up well on a job description when someone is trying to start over. So I would like to know if you all have had any conversations with the court about maybe setting a separate track for record sealing for folks who have experienced trafficking, so that it is way more confidential and less fees, of course, gone, but also a fast track so that they can get this through and get moving on their life without these prohibitions. Thank you.
Melissa Hardy for the record. Thank you, Assemblywoman. And yes, I agree. I think that's one of the frustrations, just in general, of the court system, whatever it is that you're trying to do. We'd all like it to move more quickly. And yeah, I agree in these instances that absolutely it stalls their life, their progression moving forward to get a job and put these terrible experiences behind them. And so I have not talked with the courts about doing something like that, if that would be possible. Again, I just assume it would be, a staffing issue, or, would they have the ability to do that, or are they working towards possibly doing that with the amount of record sealings that are going on, and then if some of these other bills are put into law, that they would be able to do that and assist those populations, such as victims and people in these situations, so that they can be done more expeditiously. So, that's certainly something I'd love to hear the courts stand on that. And again, what we can't control, what we can't control, we can all work towards something. But I think this is a good step to take, and then we can work on other things later in conjunction with those that are processing this and such. So thank you for that question.
Lisa Mosley, I'd like to add to that if I can. As the Assemblywoman said, we can control what we can control. It would be great, and perhaps that is a conversation I think we could maybe have with the courts, but the process is the process. One of the most prohibitive parts of the process is actually getting the funding to file for petitions. There are several processes and parts to sealing a record. One is filing the petition. There is getting your scope from whatever police department, and is getting your criminal history from the Department of Safety. So there are all of these components, and all of those things require fees and that you have to pay in order to get that. So I think the process is already lengthy, and of course we would love to see it shortened if we could. But again, one of the most prohibitive parts of that process is the fees that it costs. You have to go to all of these different places, all of these different agencies to obtain all of the different components that you need to conclude in your packet to seal your record. So if we could just get those fees out of the way, I think that would be a very good start and go a long way in kind of getting this process going a little bit faster.
If I could just add one more thing, Melissa Hardy for the record. And I know that there are some great organizations that work with individuals to help gather all this information, attorneys that do it pro bono and such like that. So I think when they kind of guide these people as to what they need and how to get the records and all of that sort of thing. So I think that that's a very advantageous thing that we have to help people. And so, you know, once they're helping get those records in a more expeditious manner, then if we can have these fees waived, I mean, I think that will speed up the process. And, you know, and sharing that information that this is available now will also help. So I think it all works together. Again, these small steps we can piece together will help. And the more that we're doing this, that it will hopefully over time speed it up overall.
Thank you. Assemblywoman Hanson?
Thank you, Madam Chair. Thank you for the work that you both are doing on this bill, and much needed. I had a question come to mind on the back of Assemblywoman Cohen about making sure we're covering. We know that a lot of times those charges could be trespass or loitering, and so we all know I'm not an attorney, so I just did a quick look, and it looks like, you know, that sub 9 of the bill, it does deal with 201.300, but it looks like trespass and loitering are in 207.200 is trespass specifically, and the loitering 207.270. So I'm wondering, you know, if we consult with legal and find out that we need to incorporate that just to make sure we're covering, because I know from prior hearings that has been an issue. And if we're looking to help these trafficked victims really be able to cover that record, we want to make sure we're including all of it. So thank you for the work you're doing. Just wanted to suggest that and appreciate your efforts.
Melissa Hardy for the record, and thank you, Assemblywoman. Yes, absolutely. I would defer to legal to, again, make sure that we're covering all of those areas that should be included. We definitely do not want to leave anything out when they're going through this process. So absolutely, if they would let me know what else we need to include, that would be most appreciated.
And Assemblywoman, there was one little detail that legal has said that they would like to see as an amendment. So we will work with you, and I know you're willing to work, but just to make sure that it's covered. Okay, wonderful, thank you. With that, we have a question from Assemblywoman Constantine.
Thank you, Madam Chair. Thank you for this bill. And what I'm asking sort of touches on a lot of things that have already been talked about. But when you file to seal your records, you have to list all of your charges in all jurisdictions in all of the state. And you have some folks who have been sex trafficked for multiple years. I appreciate that this is retroactive. So if someone was trafficked 20 years ago, 15 years ago, 5 years ago, and while they were being trafficked, they were cited, arrested for some of the things that have been mentioned, but also for check fraud, for credit things, because a lot of times they're also being used by the people who are trafficking them for all of these. So there's multiple years of issues. There can be a break in between some of the things that they have been charged with, arrested, have a record for. And since all of those will be listed when you file the petition for record sealing, if they are eligible by state law to be sealed by the amount of time, is this going to vitiate these issues about whether or not something that happened 15 years ago, are they going to have to say 15 years ago I was a victim, 7 years ago I was a victim? Or if they're automatically going to be eligible by state law, will all of them be sealed? And I can sort of go into more depth with that if that was a little bit of a confusing question.
Lisa Mosley, I think the hope is that whatever is in their criminal history, from the time they declare that they have been trafficked, whether it's 15 years ago, if there's been a break in that, anything in that criminal history that is a result of them being sex trafficked, our hope is that that entire record can be sealed. And I don't know if there's anything that the Assemblywoman would need to add to the bill to make sure that that's understood, but that is the intention.
Melissa Hardy, for the record, yes, I agree with what she said. That's the intent, because, you know, she mentioned in her opening remarks, Nevada before 2013 didn't have these laws, and, you know, since then we've been, you know, people aren't charged with these things. But before that, however many years back it goes, that their criminal records were because of being involved in this. That is what we intend to cover. So that's the hope. And if that's what this is doing, that's what we want it intended to do.
Thank you very much for that answer, because I don't see the point of a clean slate if at the end of this there is no clean slate. But my next question would be then for women who are trafficked in Nevada, because we are talking about Clark County and Las Vegas that now live out of state. They have to seal their records in the state of Nevada. Will this cover them as well?
Lisa Mosley, that is the intention, yes.
Thank you. And with that, not seeing any additional questions, I will open it up for testimony of the Assembly Bill. Anyone here in Carson City that would like to testify in support?
Good morning, Chair, members of the committee. Erica Roth on behalf of the Washoe County Public Defender's Office. Testifying in favor of this bill. I want to first thank Assemblywoman Hardy, and I appreciate the conversation that we've had this morning. You've all heard me come in here probably ad nauseum now and say that, you know, my clients are impacted by these statutes as well. My clients are victims of sex trafficking, and I often see them caught up in the criminal justice system. That can be for crimes that were mentioned, solicitation, loitering. It can also be for crimes that are related to sex trafficking, you know, living from the earnings of a prostitute. It can be related to crimes such as credit card fraud. All of these things are directly connected to their circumstances. And so this is a first step in addressing the harm, the victimization that they have endured, and ensuring that they're able to put their lives back together. A few things that I want to touch on, questions that were raised as far as confidentiality in the processes, and, you know, how practically this could work. I think a practical solution would be a self-certification, and those can be filed under seal. So, you know, however the packet is put together, they can self-certify, and if those are if the self-certification is included, that would then be filed under seal, so only certain people are able to access that information to ensure there's confidentiality in the process. Another thing I want to touch on is, and I appreciate the conversation about automatic record sealing, you know, do we just trigger this for victims of sex trafficking? I think that's a really important thing to discuss and consider, and I would note that AB 160 does have that mechanism in place and is proposing that mechanism. So I appreciate this bill coming forward. I really appreciate the conversations this morning and the understanding of how the criminal justice system impacts victims of sex trafficking every single day, and that's important to ensure that they're able to get back on their feet. You know, helping victims of sex trafficking get back on their feet, providing those services, I think that's the Nevada way, and I appreciate this bill coming forward. Thank you.
Good morning, Chair and members of the committee. My name is Caitlin Gwynn, Caitlin Gwin. I'm a law student intern here with the Clark County Public Defender's Office, and we support AB 275, and we thank you for supporting victims in their recovery. As was echoed by many before, we know that criminal records can be a major barrier to employment, housing, and they can keep victims in a cycle of coercion. Moving forward, we'd also like to echo some of the concerns brought up today and echo what Ms. Roth just spoke to. Last session I worked on a bill in which we attempted to prevent the arrest of victims of human trafficking. And one of the reasons that that bill didn't move forward is because it was difficult to identify who is a victim. We also don't know who gets to decide who is a victim, so we would support this self-certification. We know that trafficking
Okay,
looks like...
ma'am?
Yes, I'm sorry.
That part is not part of the
It's not in
bill.
there. I
So
understand.
I'm going to ask you to speak directly to the bill as written.
Sure thing. I'll strike that last part. We do know that trafficking looks like a lot of different things. It's difficult to identify, and it can be impossible sometimes. So we support continuing this conversation about how we figure out who is a victim and who can apply to the provisions of this bill. And we'd like to thank you for this important step in assisting in the recovery of victims. Thank you.
Jim Hoffman, Nevada Attorneys for Criminal Justice. The previous testifiers and presenters have said everything we would say. We think this is a good bill. We're thankful to Assemblywoman Hardy for bringing it. Thank you.
Good morning, my name is Jody Hocking, Jodihockking, founder and director of Return Strong. Simply, we are in support of the bill and are very thankful to Assemblywoman Hardy for bringing it forward. Anything that moves to remove barriers for people to be able to move forward with their lives at any point. I have one of our members who's like always saying that it's difficult to make good choices when your back is against the wall. And so I think this is a great opportunity to take that away. We have had some conversations with Assemblywoman Hardy. Return Strong would love to see the language expanded to include people who have also been victims of domestic violence that face the same types of problems, that have committed a crime under duress. And so we are in conversation about a potential amendment with that, but we love this bill and are in support.
Good morning, Madam Chair and members of the committee. Reagan Comas with R&R Partners representing Awaken, and I'll just quickly say that we are in strong support of AB 275 and would also like to work with the sponsor on making sure that all the charges that our victims face are included in this.
Good morning, Brenda Sandquist, goodness sakes, that's my maiden name. Sandquist, for the record, BRENDA, SANDQUIST. I am the executive director of Exquisite, which is a nonprofit here in Carson City, and we directly work with sex trafficking victims, and this will be a very good first step to help our victims that we work with, and so I am in support. Thank you.
Thank you so much. Is there anyone else here in Carson City that would like to testify in support of AB 275? Not seeing anyone. Broadcasting, is there anyone on the lines?
To testify in support of AB 275, please press *9 now to take your place in the queue.
Good morning, Chair Miller, members of the Judiciary Committee. For the record, my name is Serena Evans, SERENA, EVANS, and I'm the Policy Director for the Nevada Coalition to End Domestic and Sexual Violence. I'll keep it brief. I think those before me gave some wonderful testimony of really highlighting what the issue is here. And as Ms. Mosley said in her opening remarks, these criminal records haunt victim survivors and keep them from employment and safe and stable housing, which really truly only furthers their risk for re-victimization. We thank Assemblywoman Hardy for bringing this important bill forward. We know that victim survivors have suffered enough, and it is unfair that they continue to be penalized and burdened by the system. AB 275 is a victim-centered approach to reducing these barriers and is a significant first step in allowing victim survivors to move on from their abuse and have successful lives. Thank you so much.
Thank you. Broadcasting, is there any additional callers?
Yes, Chair.
Good morning, Madam Chair, members of the committee. For the record, my name is Katie Ryan, KATIE-RYAN, with Dignity Health St. Rose Dominican, and I'm also a co-founder of the Nevada Policy Council on Human Trafficking. And we are here in full support today of AB 275. Just wanted to thank the sponsor again for bringing this bill and for working with us through the interim. Thank you very much. Good morning, Chair Miller and committee members. My name is Lauren Boytel, Lauren Boitel. I chair the Nevada Policy Council on Human Trafficking. On behalf of the Policy Council, we would like to formally support AB 275 as we see this bill as a small but meaningful step in reducing costly barriers and additional harms affecting human trafficking victim survivors. We applaud Assemblywoman Hardy for her continued leadership to strengthen Nevada's human trafficking policies, and we urge the committee to support. Thank you.
If you just joined and would like to testify in support of AB 275, please press star 9 now.
Before we have our next testimony, I would just like to let everyone know that I'll be handing the gavel over to Vice Chair Marzola. But thank you, Assemblywoman, for your presentation.
Broadcast, is there anyone on the line wishing to testify in support?
Hello, this is Victoria McMahon. I'm a PhD student at the University of Nevada, Las Vegas, as well as an organizer with the Las Vegas Red Umbrella Collective. I am calling to advocate support for AB 275. My support in this is critical as I believe there are conversations that can be had about how it's currently written, but this bill is an important step moving forward. We all know legislation is never perfect and it's a slow process. And similarly, we know that the law is not always perfect at identifying victims of sex trafficking. And it is my hope that those working on the legislation do everything in their power to make sure people are not re-victimized during this process. It is a good step forward, but certainly not the end of the conversation. So thank you to those who brought this forward, and I look forward to making sure that we do more about this issue in the future. Thank you.
Thank you, and thank you for your testimony. Is there anyone else on the line?
There are no other callers choosing to testify at this time.
Thank you, Broadcast. Is there anyone wishing to testify in opposition to Assembly Bill 275 here in Carson City? I don't see anyone. Broadcast, is there anyone on the line?
To testify in opposition to AB 275, please press star 9 now to take your place in the queue. There are no callers choosing to testify in opposition at this time.
Thank you. Is there anyone wishing to testify in a neutral position to Assembly Bill 275 here in Carson City? I don't see anyone. Broadcast, is there anyone on the line?
Testify in neutral for AB 275. Please press star 9 now to take your place in the queue. There are no callers choosing to testify in neutral at this time.
Thank you. Assemblywoman, would you like to give some final remarks? But before you get started, legal just wanted me to clarify something on the record. So it states the bill applies to sealing of records of any criminal charge. The new subsection just says no fees for a petition filed pursuant to this section for a victim of trafficking who committed a crime, as in any crime while being trafficked. Does that clarify some questions? Great. Go ahead.
Lisa Mosley. It just occurred to me that I don't recall if I stated my name when I first started my presentation. For some reason, I was nervous. I feel like I've done this a million times, but every time I get nervous. So, for the record, I am Lisa Mosley, now Sales, L-E-I-S-A, Mosley, S-A-Y-L-E-S. And I am the Nevada State Director for the Fines and Fees Justice Center. And once again, thank you to this committee and thank you to Assemblywoman Hardy for your continued work and just making Nevada a better place and making us leaders in creating opportunities and restoring opportunities for members of our communities. It is just an honor to present this bill and to work on this legislation. And I think Assemblywoman Hardy is open to all of the suggestions that we heard. I know I am. And so I'm looking forward to moving this bill forward. Thank you.
Thank you, Ms. Mosley, and thank you, Vice Chair, for providing that clarification. Appreciate that. So in closing, I would like to thank the victims and their advocates who took the time to share their stories with me. And I thank the Vice Chair and the Chair and all of the committee members for hearing this bill this morning. It would be naive to assume that the small steps we take here in this building will end the scourge of human trafficking. But we do have a flashlight, and we can shine that straight into the darkness, illuminating by small acts of compassion the way forward for victims. Thank you.
Thank you again for bringing this bill forward, and I will now close the hearing on Assembly Bill 275. I will now open up for public comment. As a reminder, the time for testimony on bills that we heard today has passed. Please address your remarks to issues that fall within the jurisdiction of this committee. If you direct your remarks to issues over which this committee does not have any oversight, I will ask you to redirect your remarks. Members of the public may provide public comment either in person or by phone. Written comments may be submitted up to 24 hours after the meeting has adjourned. The phone number to call in is 669-900-6833, and the ID number is 870-901-57838. Public comment is limited to 2 minutes. And I see someone's already sitting down. You may start when you're ready.
Thank you, Madam Vice Chair, members of the committee. My name is Janine Hansen. I'm the State President of Nevada Families for Freedom. I apologize, I was not aware of these concerns on AB 231, which you heard last week and passed today, until this weekend. In that bill on page 18, section 25Y, it changes the definition of money. And it says, money means a medium of exchange that is currently authorized or adopted by a domestic or foreign government. The term does not include an electronic record, that's like Bitcoin, that is a medium of exchange. What this does is essentially exclude from the definition of money everything but a central bank digital currency, which is a government currency. And that is a significant concern because if only the federal government can have a digital currency, it puts our financial transactions and our financial privacy all at risk and threatens our liberty. And so I'm significantly concerned. When I looked at the overview and the summary that was put on the exhibits by the Uniform Law Commission, I found that information on page two of the overview and on page 6 of the summary that talks about changing the definition of money. This is a significant concern because if the federal government, including the Treasury Department and the Federal Reserve, are now in the process of trying to get ready for a digital currency, there isn't one yet, so this addresses something that hasn't happened yet, this definition, and to the exclusion of all other kinds of digital currencies. And I think it's a significant risk to our privacy and is unnecessary because there is no central bank digital currency at this time. I think it's a significant concern that we should all be aware of. And I'm very sorry I didn't bring this before. I didn't know about it. Yesterday I was traveling back from Elko because of weather on the weekend, and so I'm sorry I'm at the last minute to try to do this, but I wanted to make you aware, And if you look that up on page 18 at the bottom, you'll see that it does change the definition of money and exclude, according to their definitions, all other digital currencies, which puts us at risk. Thank you.
Thank you for your comment. Is there anyone else in Carson City wishing to give public comment? I don't see anyone. Broadcast, is there anyone on the line?
To provide public comment, please press star 9 now to take your place in the queue.
Hello, this is Victoria McMahon again, MCMAHAN. I am from the University of Nevada, Las Vegas, and an organizer with the Red Umbrella Collective. I'm calling in because I think that some of the legislation that has been provided today is a really great step forward, and I would like to invite people who are working on these kinds of things to talk with organizations like the Suede Collective and the Las Vegas Red Umbrella Collective. Definitely working on anti-trafficking stuff is super duper important in getting trafficking victims the help that they need is incredibly vital. But also sometimes the line between whether or not someone is being trafficked and whether or not they are engaging in prostitution is very blurry. And you know, sex workers deserve rights and resources as well. So I would like the people who are creating these legislation to reach out to sex work organizations like the ones that I mentioned and get their hands involved. A lot of these people, you know, some of them have been victims of trafficking and some of them have not. There's a variety of different experiences and that people can provide and offer context to. So definitely reach out to these kinds of organizations, listen to sex workers and what they have to say on these things. But, you know, AB 275 is great. I'd love to see some more stuff going forward and hopefully legislation that also includes sex workers in it. Thank you.
Thank you for your comment. Broadcast, is there anyone else on the line?
Yes, Vice Chair.
Anne-Marie Grant, ANNEMARIEGRANT. My brother Thomas Purdy was murdered by Reno Police and Washoe County Sheriff's Office during a mental health crisis. I am asking that you all oppose SB 245 should it make it to this committee in the future, which equates to qualified immunity for law enforcement in the state of Nevada. When police kill your loved one, the only form of redress in an attempt to deter police violence available is through civil lawsuits. Often, police withhold information from families, and the only way to obtain the information is through a civil lawsuit. Far too many cases end before they even truly begin due to qualified immunity, which is a barricade to truth, justice, and accountability and allows for there to be no mechanism to hold the bad actors accountable. Accountability is good for everyone and is a positive, proactive choice to take personal ownership of existing problems and potential solutions. Why is it that those who have the power to take a human life when they go to work aren't interested in accountability for themselves? They hold community members accountable every single day, and some pay the ultimate price, like my brother being tried, convicted, and executed for being mentally ill. In federal law, qualified immunity absolves police of liability even when they violate someone's constitutional rights if their actions are deemed to have been objectionably reasonable, which reasonable is used in SB 245. This SB 245 language mirrors the federal doctrine of qualified immunity. If police in Nevada thought hog-tying my 140-pound, non-combative, non-violent, mentally ill brother for over 40 minutes and asphyxiated him to death was reasonable, I ask you, what is not reasonable to police officers in Nevada? Again, please oppose SB 245 should it come before this committee. Thank you.
Thank you for your comment. And I believe that was the last caller on the line, correct, Broadcasting?
Yes, Vice Chair.
Thank you. Committee members, any comments before we adjourn? I don't see any. Our next meeting will be held on Wednesday, March 15th at 8 a.m. This concludes our meeting today.